I appear for the applicant in this application, together with my learned friend, Mr. Kirk Phillips, duly instructed by Mr. Steve May. His Lordship.
May it please His Lordship, I appear on behalf of the respondent, assisted by Advocate Ramsamy.
Yes, Mr. Yes, sir.
As your Lordship pleases. My Lord, we filed, such as is with your Lordship, on Monday, I believe, a practice note, which later in the week the respondent state party responded. My Lord, against the background of what your Lordship has in that practice note, we have had the experience in the last number of weeks of once again being given the runaround and what we would call the state, and by that we do not direct that submission against Mr. Lowe. But had the state playing what we would describe as fast and loose once again with ourselves as the legal representatives of our client. There was a meeting that took place about 5 weeks after we appeared here before your Lordship. We appeared on the 20th of January, maybe within the month. It was the 17th. And in accordance with what Mr. Lowe placed on record before this court at the time, we expected that we would receive any outstanding documents in respect of the A section, the entire B section, bar one document which had been alluded to in court by Mr. Lowe, and of course the entire C section, and Mr. Lowe had made clear that the Directorate would facilitate the disclosure of the docket. Now, we have what we have in the A section, and that we'll have to work with. We were given the entire B section.
So A section is fully disclosed?
To the best of our knowledge. There are, if your Lordship bears with me. My Lord, to place on record two things. There's a recording of the search and seizure at our client's home dealt with in our founding affidavit, which is outstanding from the A section.
A recording?
A recording. It's dealt with in the affidavits. It was a telephone.
Where do I find it in your affidavit?
I'll get that to you shortly, my Lord. While they're finding that, my Lord, if I can just continue for the sake of time.
So this recording, does it form part of the A section?
We believe so, yes. We say it forms part of the A section.
You can't say you believe it. Does it form or does
it's
it
not? It's not part of it.
So
it does exist.
Why are you putting it under A section?
So it's not there, but we say that's where it belongs and why it ought to be disclosed to us under A. However, if it wasn't part of A and for some reason was part of B, we don't have it there either. My Lord, the reference in our founding papers, my Lord, is page 14, the founding affidavit.
Yes.
Paragraph 32.5.
Yes. Paragraph?
So that's outstanding, my Lord.
Which paragraph is that?
32.5.
Page 14.
Well, of the actual affidavit, it's 14, my Lord. My little junior's papers may be incorrectly paginated, but it's 32.5, and I can...
Yes.
My Lord, it's page 12 of the actual affidavit.
Yeah.
So, we don't have that. My Lord, we today received the document.
But
yes.
If I'm looking at your notice of motion, are you seeking relief in relation to those recordings?
So, my Lord, if we, and maybe we, I'm happy to start. My Lord, turning to our notice of motion, maybe that's a place to start at this juncture, my Lord.
Yes.
1.1 is the lease docket, and we describe A, B, and C. 2, sub 2, is what we call the DEQA MP docket.
Yes.
My Lord, 1.3, so let me just clear, my Lord, this is there's something that I want to abandon. Lord, just bear with me. I've left my notice of motion out of my papers in my chambers. Damn, Lord, it appears that I'm incorrect. I thought I'd marked an instruction on my notice of motion, which I've mislaid. 3, all the informer dockets populated in terms of the national instruction. 4, all other dockets which precede the opening of the main docket. 5, the pocket book entries, etc. And then 6, we want the entire investigation and investigation diaries.
Yes.
So, my Lord, if we go back to 1, where we ask for A, B, 1.1, A, B, and C, we have A, bar what I've told you about the recording. There's one of the docket that was given to us today, which I want to come back to, my Lord, in a moment. We'll just put a pin in that, so to speak. We've now been given what we understand and have no reason to believe is not the entire B section.
So you have received the entire
So
section?
we have B, the B section.
Yes.
Bar 1 document, which until a few minutes ago we didn't know the nature of, but that has been explained to us by Mr. Lowe in chambers, and we make no issue of that at this stage.
So you accept the explanation?
Sorry, my Lord?
You accept the explanation?
We accept that explanation.
So B is fully disclosed?
So B, we've got B.
Yes, it's out of the way now.
And then, my Lord, you'll recall on the last occasion it was very, very clear in and out of court that C was tendered unequivocally. And we say on the last occasion it was an effective withdrawal of opposition. However, my Lord, in the last number of weeks there's been an about-face by the state. We don't say that's Mr. Lowe. Now they refuse to grant us the C section. Their basis, as we understand it, and it's articulated in those letters that were attached to the practice note, to the effect that we haven't made out a case. My Lord, there could be nothing further from the truth, and my learned junior, Mr. Kirk Phillips, is going to deal with that aspect in due course.
Yes.
Your Lordship will recall, and in particular Mr. Kirk Phillips will deal with Wolf's case, and you will not find in the opposing affidavit any substantive dealing with our founding affidavit on its facts, or bringing themselves within the purview of any defense, bar to say that we are nitpicking, which is not a defense, and there's otherwise absolutely no factual basis on which they can hang the hat of a defense. My Lord, if everyone has regard to the long history of this matter set out in our founding affidavit, the background facts, all of which your Lordship is aware of, and I'm not going to waste your Lordship's time in revisiting that. Our client has been dragged to court according to what we describe in our papers as either an abuse of process or a complete failure of due process. The opposition to us being provided documentation starts way back in the first urgent application. that we had to bring. It was the second one we launched. There's no doubt in our mind that if that court had the benefit and took a judicial peek as we prayed in that matter, we would have succeeded in that application, notwithstanding any other contentions in relation to urgency. But if you look at the effort with which the state has resisted our clients and ourselves, and then on the last occasion tendering everything, then giving us B, and now going back on giving us C. Well, it's difficult not to infer they're hiding something. We've been shaking this tree for a while, and we're discovering more and more, and I'm actually going to read something to you in a moment from this document that was given to us a short while ago. But the only contention, and it seems to be a contention in one of the letters, which one doesn't really make a difference, that, well, this isn't evidence. Mr. Kerr Phillips will deal with that aspect as to why this is the very evidence that is needed for a court to deal with what is set out in our founding affidavit as to the plethora of a failure of due process. You'll recall that in the papers you read in our founding affidavit and attached there to our applications in the papers in our urgent applications, the central complaint, one of the central complaints, was the way our client in a period of 2 weeks, just over 2 weeks, was harassed, her home raided. This is now coming after they've sat, apparently having investigated and finished an investigation, all to pressurize her into handing herself over. My attorney was not available by 1 day. Or should I rephrase that? My attorney was not available on the date that they wanted.
Sorry to interrupt you, Mr. Wilson.
Yes.
That aspect hasn't been dealt with by the agent court.
No, not well. Well, it's raised in these papers. It's raised in these papers, and even if it was dealt with there, it would be.
Is it not res judicata?
No, it's not. Remember, we were there. That application was set to fail on urgency.
What happened in that application?
It was set to fail on urgency. So the merits were never delved into. So, my Lord, and I'm very briefly alluding to the facts which your Lordship is aware, but very briefly, my attorney had not been available to meet on a day. It was the 17th of April, which was 2 weeks hence. He could only meet on a day, I think it was after that. That's not really important, because the difference of a day or two or even 5 ought not to have made any difference. In the meantime, they raided our client's home, and ultimately our client was arraigned, I think a day after or so. Our client was arraigned pretty much within the same time period because of changes of circumstances in my attorney's diary, to avoid her being physically arrested in a home which had been, at her home which had been threatened and with which she'd been pressured. Well, and our contention was simply this: there's no reason to even arrest her. I can subpoena her and arraign her in court. We were dealing with somebody who at the time was constitutionally the second most influential person in our democracy. She was the Speaker of Parliament. And this is how we are treated, and you know the background as to the allegations we make in relation to President Ramaphosa and the Phala investigations and hearing. Well, today we gathered a document, and it's an affidavit which was used in the course of this matter, and it describes a failed attempt to secure an arrest warrant. And that was central to the issue.
Does it form part of the papers, Mr.?
Yes, it forms. Well, we only got it today, so it's not in our papers. We were given it today, but it's part of AB. It's part of A. It should have been there from the start. Had it been there from the start, it would have been in our papers. We got it today.
What is it that you are reading?
And I'm going to read one paragraph.
What is it?
It's from an affidavit by the state in which they describe a failure. They were refused a warrant to arrest our client.
Was it disclosed by the state?
No, it wasn't disclosed until today
Where do we get that from?
from our learned friends.
Yes.
It reads as follows at paragraph 10. The full description of the document is it's an application for a further application for a warrant. It reads, a previous attempt to obtain an arrest warrant for the suspect was made at Pretoria Magistrates Court and it was not authorised by Magistrate Painter. She subsequently went and discussed the application with the Acting Chief Magistrate, Mr. Mshlangu. She returned from his office and indicated that she will not be authorising the warrant and provided a written note which is attached here too. One of the reasons cited for not granting the warrant is a lack of an explanation on the part of the applicant regarding less drastic efforts to secure the suspect's attendance in court. Prosecutor's letters set out those efforts which have been embarked on but to no avail. The point is, my Lord, as we've shaken this tree, everything we said in our urgent applications, our 2 urgent applications, affidavits, has borne fruit. We now have A, we now have B. That should have been in A before we launched this application. It wasn't. We now have it. Our complaint throughout our application is the lack of due process and the pursuit of our client motivated by different reasons and the weaponizing of the criminal justice system for political reasons. Now that we can't state as a fact, but we make out the probabilities for that case. But the point is now C is being hidden. And the only way to test the case that we put up and that they cannot answer or refuse to answer, of course, is through the evidence which the C clip contains. My Lord, I don't think there's much more I need to say. Your Lordship has read our practice note. We make a couple of other points. My Lord, your Lordship is seized with an appropriate discretion. It includes, your Lordship, if you were in any doubt, which with the greatest of respect, my Lord, we submit you can't be. But it includes you having a judicial peak of your own. We covered judicial peak in our lengthy heads of argument, my Lord. But my Lord, to the extent that...
Can you assist me, Mr. Woods?
Yes, certainly, my Lord.
What prejudice is your client going to suffer if C-section is not disclosed?
So, my Lord, look, that is part of what Mr. Phillips is going to
Or is
deal
going
with.
to deal with it?
So maybe I should rather leave it and not steal his thunder and the effect it might have in answer to your Lordship's question.
Yes.
But, my Lord, now that A and B have been dealt with...
C-section is the investigative diary.
Correct. So that is the evidence of what they did in order to comply with due process. That, the facts in our founding affidavit, we say, my Lord, and we, with respect, since I admit your Lordship couldn't come to any other conclusion on, for the reasons set out in that affidavit in the heads, set out the plethora of, in simple terms, the abusive process. Why? Simply because they've never had a case against our client. But what they've done to create such a case. And if that process was violated, they include all the violations of their constitutional rights, process and rights which pre-existed the Constitution, and the law is trite in regard to all of this. And the only way that one is going to be able to prepare for a trial like that, and all the trials within a trial that are going to come, is by access to the C-clip. But it is not, the law is not that the state have a privilege. To use that term and that description is just anathema. What they have is an entitlement to raise a defense to discovering the B or C section. Well, they've surrendered the B section after embarrassingly to themselves calling it a nitpicking exercise in their opposing affidavit. Now they won't disclose C after, on the last occasion, promising C. What are they hiding? They're definitely hiding things. Up until this morning, this document was hidden, which I've read from. But they fail in their founding affidavit, their answering affidavit, to lay any foundation for any legal argument to bring themselves within the scope and purview of a defense. It's not a numerous clausus. There's a list, Mr. Phillips will deal with it. They only suggest one new one. It's called nitpicking. It's not a defence. Other than that, my lord, if they have no reason, good reason, which forms what I call a defence to the application, well, then they should be giving us Section C. It's as simple as that. My lord, I ask your lordship to receive
Yes.
my note, Julia.
Yes.
As it pleases the court, my lord, will the lord look at paginated page 14? I'm going to use the paginated pages on the affidavit because it appears my brief might be
Yes.
erring in that regard.
Page number 14.
I'm going to start there. Now, my learned friends have said we have not made a case for disclosure of the C-section. We have stuck to the rules of drafting an affidavit. We have not raised legal argument in our affidavit. We have set the factual matrix for the arguments that I'm going to raise now. And their answering affidavit, in my humble submission, with all due respect, is merely legal argument. And when my lord, so they don't dispute what I'm saying ever. And when my lord wants to gauge whether it's legal argument or not, we just need to look at the heads of argument, and it's practically a replica. Now, if you look at paragraph 37.1.1,
Which page are you?
I'm looking at page 14 of page 34 of the affidavit.
Yes.
I'm going to refer to highlights in each section because I'm trying not to delay this matter before my lord. One of the crucial allegations in 37.1.1 is the date of Mr. Folomisa's affidavit, General Folomisa's affidavit. Now, it's 7 months prior to the opening of the docket. And you pick that up from the CAS number, which is 176 of March 2024. And you see the General Folomisa's affidavit is on the 29th of August 2023. Now that's not a silly anomaly, that's not nitpicking, that's quite vital because...
Yeah, but what's the problem with it?
Well, the problem with that is it indicates, let me explain, my lord. When you start a police investigation, the requirement is that you immediately open a docket and put the first entry in the docket. Now, this could never have been the case here. And there needs to be an explanation as to why. Now, what it actually indicates is there's another docket where this, and it must have been considered relevant to the state, that this other docket existed because it must have come from another docket. So what you have here is that the South African police, insofar as my client is concerned, were on a frolic on their own if there is no such docket. So now, when my lord looks at, well, what happened, and the further allegation is that General Folomisa affidavit is entirely hearsay. And you know that hearsay is, in the default position, is inadmissible, and is only admissible in exceptional circumstances.
Is it not a matter for trial?
No. I'll explain that to the Lord. If you read our heads of argument, we make the submission that my lord, in terms of the Constitution, is actually the most important person in this court. And my lord needs to be given the factual matrix in order for my lord to make a rational, reasonable decision, and one which is not arbitrary. So, as things stand at the moment, we are unable as a defense counsel to be able to indicate to my lord why that is significant, because we don't have this C-section. Now, this C-section could only have started in March 2024. So insofar as dealing with the admissibility of the hearsay evidence of General Folomisa, that the searching for the corroborating facts for his evidence to make it admissible will be found, well, it's not in the A section because they haven't disclosed those facts. It's not in the
Where is this affidavit?
It's in the police docket.
A section.
Yes.
Yes.
Now, so in order for us to place my lord in a position to assess the corroborating factors for hearsay evidence, which is normally inadmissible, it's not in the A section, we know it's not in the B section, and it must be in the C section. And the C section must have an explanation in it as to why a statement was taken before the police had a mandate to do the investigation in the first place. Now, that theme is repeated quite often. And remember, the background is we want the DACWA docket as well. May I just break off and deal with that for a moment? The
Are you
DACWA
dealing with D now?
Yes.
You are done with C section.
No. Okay, I'll finish with the
Yeah,
C
but
section.
why are you mixing the two?
Why am I?
Mixing the two.
I'm not going to. I've changed my mind.
Yes.
I'll take my Lord's guidance. If one looks at 37.2, now one is dealing with Mapisa-Nqakula, who is the 204 witness in this matter.
Yes.
Now, it is our case that the 204 certificate that she was granted made it impossible for her to be indemnified in this trial because there was a failure of its drafting. But now it becomes additional.
Let me understand your submission. Are you saying she was given a Section 204 certificate?
Yes,
In which matter?
in this matter.
The trial hasn't yet commenced.
Well, her affidavit starts with a certificate in terms
No,
of...
but what certificate is that?
No, I see my Lord's problem. My Lord indemnifies the witness, I understand that.
No, but you only, in terms of the law, you only indemnify the witness after testifying.
Indeed.
And if you are satisfied with the evidence, whether was he telling the truth or not, then it's when you can indemnify the witness.
Yes, but the state promises the witness that if she testifies to their satisfaction, notice to their...
Yeah, but that's not their space.
I agree, my Lord.
That's not their space. They can promise whatever heaven and earth. But if I'm not satisfied, as a trial judge, I cannot indemnify that witness.
I'm so pleased my Lord raised that, because the surrounding circumstances of the 204 certificate, which in our opinion, the promises made to her were inaccurate, which makes the freeness and the voluntariness of her making that statement suspect. Now we only have the certificate in the purported certificate in the docket, and the Lord has said, well, it shouldn't be there, I'm not going to take that point.
Yes.
But the circumstances of her becoming a 204 witness will be in the C section of the docket. It's nowhere else we can't find it. Now, it's also additionally significant that this affidavit by this 204 witness was taken 7 months before this docket was opened. Now, the explanation for that we don't have yet. And we do know from the facts in the urgent applications and the like that her matter was withdrawn, and 2 days later my client was arrested, and this matter was enrolled against my client. So I raised that suspicion. Now I'm raising the suspicion with a great deal of care. My Lord is not here to decide whether the 204 certificate, which my Lord said shouldn't be there, but is there, was appropriately, whether that certificate or that undertaking was appropriately given to the 204. We're not trying to ask you to find that she should be indemnified. What we are asking you for is the surrounding information relating to her being given that promise. In other words, was her statement freely and voluntarily made without any undue influence? Now, when you have a 204 witness, you're asking that witness to confess. Otherwise, she's not a 204 witness.
Yeah, but is it the duty of court to determine whether the statement was freely and voluntarily made?
I'm so glad the Lord raised that, because we are looking for the facts around her taking that statement, and that will be housed in the C section, not in the A and B section. And insofar as us presenting a case to your work that she was my Lord, I beg my Lord's pardon, insofar as presenting a case to my Lord, we must have the same information that the state has. And already when my learned friends argue that this is not relevant or nitpicking, my case to my Lord is very clear that it is highly relevant to the decision of the credibility of this state witness. Now, if you look at page 16 of 34, paragraph 37.2.2, the founding affidavit.
Yes.
My Lord has said only my Lord can make that finding, but look what is said here. I have not been promised any indemnity from the prosecutions or amnesty for any crime. Now, it could never be any crime. If that information given to her was correct, the indemnity would be given for the crimes on the charge sheet in this case. Now, we need to know the circumstances as to why she made the 204 statement. Now we need, before she made a 204 statement, the Lord will remember that she wasn't accused. So there would have to be...
She was accused in a separate matter.
Yes, but she
was not a co-accused.
Yes, but it would still be necessary, my Lord, for us to examine the circumstances in which he made the 204 statement. So we would need to know whether she was warned according to judges' rules prior to making the statement, inter alia, whether she was warned as to whether...
Is it a requirement?
Well, it started out as a confession, and then she changed. So in assessing how it came when she was self-charged for, I think, 250...
Yeah, maybe I'm getting lost, Mr. Phillips.
Yes, my Lord.
Did she make a confession?
We don't know. We'd like to find out.
But I heard you mentioning a confession. That it started by her making a confession.
When you make a 204 statement, you are admitting that you were involved in a crime which the accused on that charge sheet is involved in. So you are actually making a confession. So all the requirements of a confession being freely and voluntarily made would have to be satisfied before that evidence would be admissible. Obviously, my Lord, that's not our only point, so if my Lord is not happy with that point, I will continue.
I've never indicated that I'm not happy with that point.
As it pleases the court.
I'm trying to establish what, so that I can understand your submissions.
Okay.
Yes.
She wasn't accused. She would have been warned according to judge's rules. She had to. That would be in the Decado. She would also have been warned in terms of the Constitution. She would have had to have had an attorney. That attorney would have advised her, is it appropriate to make a 204 statement or not? If she didn't have an attorney, then it explains the ineptitude with which her statement was drafted. That's the kind of fact that we're looking for.
Yes.
Now, also, my Lord, we want to assess and this is at paragraph 37.2.2.7, page 18 of 34. We need to assess the incentive, what the incentive was for her assisting in this matter. Now, then if she made a further statement, and I'm not going to refer anything more to that statement, other than it starts dealing with her credibility as a witness, which we don't have the full facts of disclosure of. So, if we have the C-section in this matter, we will know the circumstances as to why she was called as a 204 witness, and we would also have a reference to the other dockets from which these statements come, which we would in turn be entitled to disclosure of.
Yes.
If you look at paragraph 37.5, There's a statement by Noel Ndlovu, also 6 months prior to the Lytton docket. So this is the husband of Nombasa Ndlovu, and obviously the same point is being made from what docket did that originally come, and the C-section would indicate why we should get disclosure of that docket. My suspicion
Is he also a Section 204 witness,
Yes,
Mr. Ndlovu?
yes. If you look at page 20 of 34, paragraph 37.6, again, there is a statement of Habisus Atinya, A6, dated the 11th of September 2020.
Paragraph?
Sorry?
Which paragraph?
37.6.
Yes.
Yeah. An affidavit by that witness, filed as A6, dated the 11th of September 2023, 6 months later than the Lytton docket, and out of sequence. Now, the out of sequence is also significant because a C-section should be a chronological list of when the investigation took place. And when there's a statement filed out of sequence, the inference is that this is being inserted irregularly, because the C-section should be an index of the progress of the investigation. But that's not the only point. The more important point is the 6-month story. If you look at paragraph 37.7, General Sizani, filed as A7, also dated 6 months before the Lytton docket and out of sequence. If one looks at the affidavit of Nosiviwe Mapisa-Nqakula, filed as A8, 6 months earlier than the Lytton docket, and the legal advisor to Dr. Guluba. The same would apply to the affidavit A9, also dated, this is now at page 21 of 34, paragraph 37.9. The same would be true of the witness in paragraph 37.10, 37.11, 37.12, 37.13 on page 22 of 34, 37.14 at paragraph 37.14, then 37.15 is also significant because it's our submission that if you read the affidavit, it's not relevant. So obviously the relevance would be found in the C-section because it appears to be on the facts completely unrelated to this matter. 37.16 is the 5-month story, A16. .21 on page 24 of 34. This is a transcript of WhatsApp messages filed as A21. There's no indication of the expertise of the translator. No evidence is provided about the author, authenticity, or originality, and thus the admissibility of this evidence. Not asking you to make the finding now that it's inadmissible. I'm asking the Lord to allow me to put my hand on the facts to challenge that evidence in the trial. It's a very important distinction that I'm making. 4 statements in terms of section 236 of the Criminal Procedure Act by Lillian Coco. Now that's very significant. That's very significant, my Lord, because this should have been, the process of getting this document should have followed a 205 application. in terms of a Criminal Procedure Act for access to bank accounts. Now, why is that significant? Because a 205 application rather requires a reasonable suspicion. So we want to know how this is dealt with in the C section in order to be able to prepare for the admissibility of these documents. The Lord, I'm skipping some of them, although
Yes.
I'm not departing from their significance in my address. The Lord goes to page 25 of 34, paragraph 37.23. This is a 212 CPA statement. Again, I would submit that a 205 application should have preceded this. Now, we might find out in the C section why. And we already know that documents were only disclosed as late as today. So if we shake this tree again, we might get what we're looking for. But we don't want to be before my Lord shaking the tree endlessly. And if we get disclosure to the C section, we won't have to shake anymore because we'll know exactly what the state has in their various documents. Lord, I'm going to allow the Lord to read the rest of the affidavits,
Yes.
each with their objections, each motivating why there should be disclosure of the C section. Now, if the Lord understands, and this is dealt with in our head of argument, reads through the relevant standing orders of the South African court, South African police, the Lord will see, and that's why they're there, that my Lord would see that when the C section is drafted, everything that I'm saying should be there. Because the standing orders of the South African police require it. Now, I anticipate my learned friend's argument that the standing orders are a guideline. Well, they're sort of like the Schedule 8 of the Labour Relations Act. The guideline is closer to a law than a guideline. But the point of the matter is, even if they succeed with the argument, it being a guideline, and I'm going to deal with that in a moment, even if they were to succeed with that, it appears from my address that thus far in my humble submission, my Lord, that every guideline that applies, they've studiously avoided. Now, if we get disclosure of the C section, and that is indeed the case, then we would be far better prepared for this trial than we are now. So, if my Lord then looks at page 29, I bring all these arguments, well, myself and my learned leader bring these arguments together. There's hearsay evidence. The support of corroborating evidence for the hearsay evidence is not in the A section. We know it's not in the B section. So it must be in the C section because the state are relying on hearsay evidence. There are accomplice cautionary rules like a single witness, a co-accused cautionary rule. They're not dealt with in the A section. And my Lord, that's why we were so careful to summarize every statement that we have been disclosed, bar the one that we got today, which would have been very useful when we appear before Her Ladyship Pottrell. But the point of the matter is, my Lord, the point of the matter is, all of these conclusions in paragraphs 39, 40, right to the end of the matter, justify, first of all, unlike what my learned friends say, they are evidence of why we want the C section. So there's absolutely no issue that we've made out a case for the C section, for the DECWA docket, A, B, and C section, and to any other docket from which these statements come from. Now, my Lord, and once again, referring to the statement that was disclosed today, we want to be able to spend less time shaking this tree so we can get on with the trial. When my Lord looks at the affidavit in answer, and I issue this challenge to my learned friends. Where do they deal with these issues? Now I'm going to briefly refer to the onuses and the duty to produce evidence, which is dealt with in our heads of argument, but it's crucial when my Lord looks at the answering affidavit, and then I'll reply. We have an evidentiary burden to show why the docket should be disclosed. Now, I want to qualify that. The requirement of an evidentiary burden came from the interim constitution. It's argued in our heads of argument that there is no longer any evidentiary burden. Maybe it was out of caution, we still were very careful to lay an evidential basis if my Lord finds I'm wrong in that regard. So in terms of the final constitution, we're entitled to disclosure. Now, in terms of the National Prosecuting Act and the South African Police Act, the sections are referenced in my heads of argument. The South African police and my learned friends for the state are bound to comply with their regulations and their standing orders. If you read the relevant sections, my Lord, you will see that, for example, with the South African police, the National Commissioner has a right to issue what are now called general orders. They're no longer called standing orders, but the content is the same. And the subsequent sections of that act specify specifically that the South African police must comply. And it's called a standing order, not a guideline. Insofar as the regulations for the prosecutor, there are matching sections in the National Prosecuting Act, and the terminology is they must be complied with. So when you picture in your mind a C-section, it must be quite literally a perfect document explaining all the due process procedures that the South African police and the prosecution follow. My learned friend is saying no, but perhaps she can say it when she has her turn to argue.
Yeah. Why are you doing that, Ms. Ramsey?
My Lord, I didn't interact with my colleague while he was speaking. I'm actually taking notes under the podium. I'm not sure what my colleague is referring to.
Yes.
As it pleases the court, my Lord. So when one looks at a C-section, there should be a step-by-step process of the due process steps taken to secure the evidence in the A section. Why is that important? We go back to Chabalala. When one looks at Chabalala, the onus on the state, and first of all, they do not decide what's relevant or not. They give us everything, and then when the issue of is it relevant or not, it's argued in the normal process before the presiding officer of the trial why it is or isn't relevant. They don't decide relevance at all. My Lord, you do. Because you are exercising judicial oversight over the due processes of securing the evidence against the accused. Secondly, my Lord, it is all about due process. And we have prepared for you. There were other cases in this bundle which we prepared for you when the matter was before my Lord in January, but I'm going to hand up the file. The particular case that I'm referring to is Donovan Wolf. I might hand up the file. I understand they were disclosed. Now,
yes.
That case is a very recent case of the Eastern Cape Division. If my Lord gave a judgment in our favor today, it would be our respectful submission. We applaud that judgment. It would be our respectful submission that my Lord would largely follow that judgment, alongside all the other cases that we have cited. But what is crucial in that judgment is it refers again to the onus on the state. Now the onus on the state is declared in the Chabalala case, and there are categories like informer privilege, international treaties, secret police methods, and so on. nowhere in the answering affidavit, and the issue of informant, I can't remember the fifth one, nowhere in the answering affidavit is there suggestion that we're not giving you this because it's a state secret, we're not giving you, it relates to an international
So
treaty.
what they're actually saying is that it doesn't exist.
What doesn't exist?
The informers' information and other things.
Answering affidavit is that case later. So insofar as my submissions are concerned, there is an evidential burden, which I say we satisfied with aplomb, and there is no evidence in the answering affidavit which applies the Chabalala prerequisites. And what is interesting about the Chabalala exceptions, if I may put it that way, which the state can rely on not to disclose, they all relate to due process. That's why the Wolf case is important. Because the Wolf case, like King says, the defense can't have every document in the state's hands, and we know about this memorandum which we're not contesting. But if you look at the King judgment, in the first 4 paragraphs of the King judgment, my Lord will see that the A, B, and C sections are not at the lunatic fringe request that was made in the King's case for a dedicated index for every description of the document and the reason why the state was not disclosing it. And obviously that was a tax case, so there were thousands of documents. We're not at that lunatic fringe. In paragraphs 1, 2, 3, and 4 specifically say that as a matter of course, but for the Chabalala exception, disclosure of the A, B, and C sections should be made. It's also significant that those paragraphs deal with the term used in the heads of argument, namely state brief. The docket is a subsection of the state brief. In my experience, when I first launched applications like this, in the Johannesburg Regional Court, prosecution would have 2 cabinets in the court. And you ask for disclosure and they would say, that's my cabinet, I can only give you what's in my cabinet. And that is another prosecutor's cabinet, I can't give you what's in it, it's not in my possession, therefore you can't have it. Now, obviously, the argument raised by the state for that kind of sophistry has become more sophisticated. In this case, they say the Dekwa docket belongs to a different subsection of our organization. Therefore, it's not in my filing cabinet. Therefore, you can't have it. Now, we've already dealt with the statements which must predate the C section in this docket. So, if you look at the King judgment, it refers to state brief. And, my Lord, in the heads of argument, we deal with the historical position that before 1994, the state tried to make the state brief as large as possible because it was privileged. And then Chabalala threw out that reasoning. Now, everything is part of the state brief as it was then, and there's not a case that myself and my learned leader have been able to find where it distinguishes from the broad definition of what the state brief is. So we're asking you to give us our prayers in the notice of version, because the state brief consists of everything that is relevant to the proper pursuit of this trial. And I rely on the Wolf decision, which specifically says, when issues of due process are raised, it makes absolute sense that the state get the A, B, and C section of the document because it relates to due process. And due process is not canvassed in the A section. And if there are cases where it is, it's not in this one. In this docket, the only issues raised by this docket, for example, the predating of affidavits, creates that cloud of suspicion, that evidential burden that I have to satisfy. That full disclosure should be made. And I don't want to be like a stuck record. We're shaking that tree. And my learned leader read an affidavit today, which we only got before the Lord came in, saying we asked for a search warrant, we didn't get it. And my Lord, the papers for the Ladyship Potter's application are part of the papers. I'm not suggesting that you have to read them, but I imagine the result would have been completely different if she had known that. I have nothing further unless my Lord wishes.
Yeah, but is the state refusing to disclose the DICA docket?
I didn't hear the question.
Is the state refusing to disclose the DICA docket?
Is it a question?
The issue is, my Lord, is it's in my humble submission, sophistry that the state they're saying, when we finished the investigation, now the matter was enrolled against Ms. Nqakula. So we already know the test for enrollment. It was a reasonable prospect of success. They are saying the investigation is not complete. Well, I hope Ms. Nqakula is listening, because she's got a really cast iron intellectual claim, because they are now saying they weren't ready to arrest
But does that tantamount to refusal?
Okay. Well,
What they are saying is that at this stage we can't, because the investigations are not yet complete. Meaning that if the investigations are complete, they can disclose that docket.
Lord, I go back to my argument about the enrollment of the matter. The matter is enrolled when the investigation is complete. And it's very important, going back to the onus of the Chabalala case. They don't say what investigations still have to be done. They merely, just may I take an instruction?
Yes.
My learned leader, so my learned leader is raising the same point I raised a moment ago.
Yes.
That it's not dealt with in the affidavits at all. That's the reason why the Descartes docket cannot be given to us, and the reasons why they're raising changes today that the investigation is not complete. And the matter was taken
Yeah, but
off.
it's a recent development following the appearance of the 23rd, where parties were afforded an opportunity to go and sit and discuss this issue pertaining to the docket.
Where is it in the affidavit?
No, they filed a practice note subsequent to that.
It is,
They filed a practice note detailing what happened.
and there's a letter from, I think her name's Anthea Johnson, where she says, we're not making disclosure at this time. In my respectful submission, that's just evasive buying time. And I can
Yes.
see no reason why they shouldn't disclose it now.
Yes.
Is there anything else?
No, it's fine. Let's hear your colleague.
Might I just take one more instruction?
Yes.
As it pleases the court.
Yes. Who's arguing? It's you, Mr. Law.
Thank you, my Lord.
Yes.
My Lord, when I took over this case, I totally reassessed the situation, and I must place on record that, I hear words like run around and about turns, but I can assure the court that the investigating director of the National Prosecuting Authority has made a bona fide attempt with one reason, as I've stated before, and that is to move this case to trial as soon as possible. The efforts to facilitate the request of the applicants with regards to the Dekwa docket It's a complex situation and a rare situation that was advanced, and we reassessed the situation and we made concessions where necessary. My general approach to this is, first of all, I took cognizance of the applicant's case. The fact that she claims that it's based on hearsay, the evidence of a single witness, potentially inadmissible evidence, and she also challenged the credibility and integrity of the state's investigation and evidence. And then I reminded myself that the prosecutor is not an ordinary litigant. It is an undivided loyalty to the proper administration of justice and the truth-seeking mission of the criminal justice. And in this spirit, we approach this case. In summary, the prosecutorial discretion in criminal discovery involves making critical decisions about disclosure, timing, scope, and management of evidence. The NPA's Code of Conduct is very clear. As soon as possible, we must release, disclose to the accused any prejudicial and beneficial information. And this is the right to a fair trial is a very important right, and it's a continuing duty until the end of the trial that of disclose. Mr. Kerr Phillips alluded to relevance. Relevance, my guiding light, is apart from Chabalala, the final order of Chabalala. The King, National Director versus King, paragraph 1 states, this means that an accused is entitled to the content in the docket relevant for the exercise or protection of that right. The entitlement is not restricted to statements of witness or exhibits, but extends to all documents that might be important for an accused to properly adduce and challenge evidence to ensure a fair trial. And in that spirit, my Lord, the remark in the Canadian case of Rex versus Eddie, and I've got soft copies of all those cases, say what is relevant. One measure of relevance of information in the Crown's hands is its usefulness to the defence. If it's of some use, it is relevant and should be disclosed. And then the court referred to Stinchko. They said this is a requirement, a determination by the reviewing judge that production of the information can reasonably be used by the accused either in meeting the case for the Crown and advancing a defence or otherwise making a decision which may affect the conduct of the defence, such as, for example, whether to call evidence. My Lord, in that spirit, I approach the B section.
Why don't you disclose C?
Tell the court now. The B section consisted of summonses. A pile of summonses was disclosed to the defence on the 17th of February. And Mr. Phillips, for instance, talked about the 205. In our directorate, we do not use 205, we use section 28 of powers in terms of section 8 to summons information. That will answer the question. Further, I would like to say that if we look at paragraph 37, the accused already built a timeline of events. This summonses will enable them to populate that timeline of events and timeline of the investigation even further. My Lord, if we look at the C-clip, if we look at the national instruction, I would like to begin the national instruction of South African Police, which is a guiding light. An investigating diary must be maintained in such a manner that it contains a complete chronological record of all work done in the case. And it serves as an index. But then, I don't want to read the whole instruction, but subparagraph D says it serves as a proper and convenient medium for the conveyance of instructions by inspecting officers or a member as well as request by the prosecutor. My Lord, this indicates, this saying to me, that this is work product, can be contained. In other words, in the diary, other words, mental impressions, opinions with a view to litigation. And that is privilege. So when my colleagues answered and said privilege, this is what they meant. Then subparagraph E says, serves as a reference in court should any aspect of the investigation process be brought into question. Means that this diary can come to the fore, as had happened in the Donovan Wolf case, and I will refer to that at a later stage. The Lord, the respondent's answering affidavit, paragraph 103, says the C section, and I quote, of the docket is the investigating diary and does not contain evidence. It contains privileged and confidential information pertaining to the investigation in the context of the averments made through the applicant's founding affidavit. Nowhere is a case made that disclosure of a C section is relevant to the applicant's fair trial. And that paragraph basically says it all. If we, for instance, analyze the applicant's argument, it's clearly 5 points. First of all, they want access to the C section for a verification of a full disclosure. The point that's made is that the C section acts as an index to the A section, ensuring that all relevant documents and statements have been disclosed. Secondly, chronology and accuracy. The C section contains a detailed record. And then one of the points they make is preventing fabrication. The detailed entries in the C section prevent the possibility of fabricated evidence. And if I can then lastly summarize, contextual understanding. They need it for contextual understanding. The C section provides context to the evidence presented in the A section. And indeed, the founding affidavit, Mr. Phillips, I'm not going to repeat that, paragraph 37, refers, for instance, to the fact that one affidavit was made 7 months before the opening of a docket. They refer to the fact that Wynand Wessels, Sunil Belichan, and so forth, and the other witness affidavit was not filed in sequential order. Now this creates suspicion of affidavits taken before the opening of a case docket, and some affidavits are not filed in a sequential order. My colleagues in their answering affidavits state clearly there's no other police docket. My Lord, and for us, the answer to these suspicions are very simple. For us who work in this space and that investigating...
Why is it so that a statement is obtained 6 months and later on a police docket is opened?
My Lord, we understand the inner workings of that investigating director. The investigating director would authorize an investigation either in section 2830, which is a preparatory examination, or a full investigation in section 28.1. Then evidence would be gathered and filed, and only months after, once a decision had been taken, a docket would be opened. It's a very, the methodology of that investigator is such, it's an easy explanation. It doesn't work like other ordinary cases where a docket was opened and from that day onwards. Indeed, my Lord, the investigating diaries in the case docket are not from the time of registering the case docket, but from the time the investigation was started and concluded, as well as post the opening of a case docket. Case docket diaries are usually started from the time a case docket is opened, but in this case, started from the inception of the investigation. The affidavits, the fact that it's not filed in sequential order, is also neither here nor there. You cannot infer a conspiracy. The affidavits have been filed according to the contextualize and corroborate the flow of the evidence the investigators collected. It is not a requirement for the investigators to have filed the affidavits sequentially, as the case docket was only opened shortly before the case was registered. The investigation was conducted through the authorization of the ID. So these things can easily be explained. In my view, respectful view, the applicant is already in a position to determine the chronology of the investigation. She could build her own timeline of the investigation based on the information supplied. I was of the view that the simple showing of a diary, and this is on the previous occasion, the diary should provide the contextual understanding the applicant was seeking. But if the insistence, and this is perhaps where I was wrong in my approach and was made aware of that, if the insistence is to gain access to the whole C-clip, then public interest considerations come into play. Perhaps there I was wrong in my approach. Example of a case where the accused was successful was the case of Donovan Wolf, the case Mr. Kirk Phillips alluded to. The accused Donovan Wolf wanted to access the C section of a police docket to challenge aspects of a police investigation. He aimed to gather information that could be relevant to his defense, particularly concerning the alleged planting of knives at the scene and the relationships between the state witness and the investigating officers. Access to the C docket was sought to ensure. Now, the three broad grounds for this approach or this request was first relates to the alleged pressure brought to bear on state witnesses to change or to adapt their version. There's evidence in that case. So in that case, it happened during the trial. He could apply for it, he could, and then exercise his right. The second one is based on the relationship between the first state witness called to testify and both the initial prosecutor as well as the wife of the current investigating officer. Again, Mr. Wolf made a specified, specific allegation why he should gain access. He went through a process where he asked for further particulars, and then with the discovery of certain information, he could ask for this discovery of a C-clip as envisaged in the national instruction I alluded to first. But then the next point is what happened in that case. The state failed to demonstrate reasonable grounds for believing that disclosure of Section C information would impede the proper ends of justice. The state failed to demonstrate reasonable grounds. An accused person should therefore make a detailed case for access to the question to whether there are other mechanisms available to obtain that information. In this case, Donovan Wolf is an illustration that the application for discovery can be made during the trial. That an accused can use other mechanisms to obtain access to information, and the other feature of the Donovan Wolf's case is the application must be specific. If a state shown that discovery may, and the state must show that the discovery may impede justice, which was not done in Donovan Wolf. What is the difficulty with a broad application? I would like to refer the court to an English case, Rex versus H&C, 5th of February 2004, where it said the following was said, paragraph 31. The trial process is not well served if the defense are permitted to make general and unspecified allegations and then seek far-reaching disclosure in the hope that material may turn up to make them good. Neutral material or material damaging to the defendant need not to be disclosed and should not be brought to the attention of the court. Only in truly borderline cases should the prosecution seek a judicial ruling. And the question today is, what is material, what is worth protecting in the C-clip? And I can only stand by what was said in paragraph 103, which I started off of the answering affidavit. And I would like to provide detail, if possible. But the investigating directorate must protect people who refer cases to them in terms of Section 27 of the NPA. Also, we must protect privacy of individuals. That's why the one document was not disclosed in the B-clip. And then, ever-changing situation is witness statement. Only those three. And if the court decides, yes, can the accused's interest be protected without disclosure be ordered to an extent or in a way which will give adequate protection to the public interest in question, the court should consider that option. This stage, the question is the C section the only source of evidence? The answer is no. We already have the evidence, the A section, the B section that was discovered, and secondly, we cannot raise a reasonable doubt. Can it be said that the accused cannot raise a reasonable doubt as to his or her guilt in any other way? Clearly, she can. There are many mechanisms. My Lord, I would like to close off with the case of Eddie, which I referred to Supra. In the case of Eddie, the Canadian case 2014, as the Saskatchewan court in paragraph 50, court refers to Rex versus Anderson in paragraph 74. There is a point where pure explanations.
Are you going to provide me with all these authorities?
My Lord?
Are you going to provide
Yes,
me with
I said soft copies will be emailed. Thank you. What Mr. Anderson submits is the possibility of an arguable defense in the material sought cannot be eliminated, and therefore the Crown must disclose these items to make sure there is no stone unturned. While this is theoretically true, it is not the law. The obligation of the Crown to keep disclosing more and more peripheral material is not conditioned by the defense speculation that there might be something of significance which might be usable by the defense. The Lord, in this case, paragraph 104, Ms. Eddie's request for time and date, she went further than just a mere trial. She went for time and date information and documents, metadata appear to relate to a particular objective. She submits that in order for her to properly prepare a defense, she needs to construct a timeline of the investigation, when the investigation began, what steps were taken during the investigation, and even when certain documents were created, accessed, and modified. In order to do this, she requires disclosure of the internal time codes used by the police, and the source data and metadata. The Crown, on the other hand, says that she could create her own base, her own timeline on the information that has been provided, if not the Crown's obligation to do so for her. The same argument was advanced regarding the source data or the metadata. And in the end, the court ruled that if it's for purposes of timelines, chronology, it's not necessary to go that far. The accused can build their own timeline. The question we must ask, in closure, my Lord.
You don't have a South African authority on that topic?
No, not that I could discover that. The non-exhaustive factors is the essential elements. Do they have enough evidence to address the essential elements of the offence, the complexity of the investigation, and what the state refuses or is unable to provide, whether it's part of the case to be the interaction. My Lord, I just want to say that there is enough evidence, information, and that there are certainly public interest exceptions that needs to be protected in that situation. I just lastly would like to refer to the Lekwa docket. My Lord, I am a firm believer of Mr. Justice Mavundla's words in the McBride versus Regional Magistrate Pretoria, when he said in paragraphs 21, 24 in that judgment, that if Prosecutor A doing a prosecution and is made aware that there might be information in Prosecutor B's case, that there's a certain onus. And I can just say that the investigating directorate's position is that docket is not in our possession, not under our control, not ours to give. That is true. But Mr. Justice...
But are you not representing the state?
I'm representing the state. But the onus is on Prosecutor A to, first of all, always consider discovery. Secondly, he must obtain the information from Prosecutor B when possible. Remember, I said the MPA's Code of Conduct said as reasonably possible, beneficial or prejudicial information must be disclosed. Thirdly, the judge said there must be cooperation between the two prosecutors' offices. Fourthly, the judge must say there must be a value judgment by Prosecutor A to ascertain the relevance, and he must not just have a blanket opposition to refusal. That is my guiding light here. And if I can put it in another way, Prosecutor A must follow all reasonable lines of inquiry. If he's made aware that there's evidence in possession of Prosecutor B from a different unit, that is another reasonable line of inquiry to be followed. And that the state will do the moment, and I say the state, I mean the IDAC, investigating director, once that case is ripe for access, because there's always information in terms of our Code of Conduct cannot be divulged from cases that's under investigation. Now, it's true that case had been enrolled many years ago, but new representations had been made that had to be investigated. It's just not sensible to obtain that information and disclose it to an accused when a next statement can change that line of inquiry and put a new slant of the evidence. We had to wait.
But the accused in that matter she disclosed the docket.
In McBride's case.
No, in the DICA matter.
My lord?
In the DICA docket. Numbers, is it numbers or?
Non-Barsa, she's the accused.
Was she not disclosed the docket? Was she not disclosed the docket?
She was disclosed the docket as it then was.
So why don't you give them the docket?
Because the docket, my lord, there's additional information
now in the public
which can have, and I can only make that assessment once it's finalized. And that process is almost completed, my lord. But that I just want to place on record. Thank you.
Yes. Who's going to reply?
Lord Bar, what I'm going to say to you, I wouldn't have much to disagree with what Mr. Lowe has had to say. It's been an interesting set of submissions on the standards and the requirements of the prosecutor. Mr. Lowe is only a recent incumbent to this matter, but where in any of his submissions does he tell your lordship how any of this that he has had to say to your lordship applies in this case? Not one submission. Just simply says that they don't have the DECWA docket. I don't believe that, my lord. It's false. I'm not saying Mr. Lowe is misrepresenting the truth. It's just that the state and the investigation in this case had access to that docket. There can be no doubt about that.
What Mr. Lowe is saying is that it's in another unit of the NPA.
My lord,
that's why I'm saying to you, is he not representing the state?
My lord, the original might be there. Where have they told your lordship where their copy? Do they want? Does this directorate want your lordship? If they want your lordship to believe that they've never had sight of that docket, on what basis must your lordship accept that? Because it's not on the papers before your lordship. They cannot advance that argument. And that's why they keep dealing with when they answer our correspondence. We read a little bit here, a little bit there in a letter. One would have expected in the passage of time, which has been lost on account of the state's conduct, to have had an application for leave to file further affidavits. You don't have that. My lord, the three Canadian cases referred to have no application here on my learned friend's submissions. In Eddie's case, that's about interrogatories that as we listen to submissions, because we weren't forewarned of these cases. But as I listened to his submissions, it was all about interrogatories being made of the state. Your Lordship asked, well, is there a South African authority? Well, there will be, because our court wouldn't accept a witness speculating. We've laid out a factual basis in our founding affidavit for why we want the disclosure of all 3 sections, of which we already have 2, and of which they initially never gave us everything in the first one, and then they refused to give us the second one. And on that score, my Lord, we're not asking, and this was raised by Mr. Lowe in relation to Rex versus Eddie, we're not asking for information interrogatories to build a timeline. We just referred to a timeline as a description of what one finds in the C-clip and how it should look. And it should be a perfect document, as Mr. Phillips said. We're not looking to construct a timeline. But then Mr. Lowe did say that, well, if they go and the documents they now have in B, if they just go and construct that, they'll have their timeline. Well, we didn't ask for a timeline. But thank you for the concession to just give us the C section. Why must we go and guess in a matter where we've questioned almost every procedural step they've taken with evidence, as Mr. Kerr Phillips argued? My Lord, in relation to Rex versus H and C, well, there it dealt with vagueness, as I listened to my learned friend's submissions. They haven't accused us in their answering affidavit of being vague. They never could. Your Lordship's seen that founding affidavit of ours. They don't accuse of vagueness. They say we're nitpicking. In other words, their actual contention in their answering affidavit is to say, well, these chaps are looking for documents, they're nitpicking. We specify what we've got, and out of that what we take issue with and what we believe we should have. In relation to Rex versus Penny and relevance, and yes, relevance, of course, that's how do you test relevance? You must test the usefulness of that document to the accused. How do we do that in the circumstances? We've already raised a case as to relevance. Mr. Kerr Phillips dealt with that. Hearsay and all these other matters. Well, my learned friend explained to your Lordship that, well, they don't use section 205. They use section 28. Well, that was news to us because we haven't seen anything in A and B in relation to the recordings that would be the result of section 28, the audio recordings. So that's all going to be in the C clip. So, but Lord, we shook the tree a bit today, and that's what we got.
What is it, Mr. Lowe?
Lord, sorry, I forgot to place on record. The audio was made available through the defense, yes?
January.
17th of January. Was delivered to
the
Mr.
audio
May.
recording.
Yeah, audio recording and then the outstanding.
Was it disclosed to the defense?
May I think that's the outstanding?
If I may just clarify,
Yes.
my Lord. My Lord, in the initial papers, the applicant indicated that there were 2 statements outstanding and a recording of the scribe. On the 17th of January 2025, the investigating officer took a USB containing the entire docket again, including the recordings, to Mr. May at his offices. In fact, it reached a point where I had to call him because he was in the process of moving offices so we can get the new date. We are in receipt of a document where they confirm in writing acknowledgement of the USB. At the roundtable meeting, Mr. May, it was agreed that Mr. May would bring his USB, we would go page by page, myself and him, so as to confirm that he has everything in the A-clip. On that particular day, Mr. May at the roundtable indicated he hadn't even opened our USB.
He doesn't do what?
He had not even opened the USB.
Yes. When was this?
on, when was the one? 17th February. So a month later, the USB that the state had provided to the officers had not even been opened. And state confirms that in that is the recording of the scribe of the search. Thank you, my lord.
Mr. Wilson.
My Lord, this is submitted from the bar, taken by surprise. We don't have it. If we do have it, we should have found
Mr.
it.
May is here. Why don't you take instructions from him?
My attorney has already given, I called for the instruction. He says he has no knowledge of on the disc.
He didn't receive the USB.
But here's, no, we got the USB. That's not the issue. It's what's on the USB, what they say is on the USB. So, my Lord, here's the point. They're not objecting to giving it to us. The Lordship can record that in an order. However, Mr. Lowe took the opportunity to raise that now on the recording in relation to the search and seizure. That's not what I'm referring to. If there are other Section 28 procedures followed, there would be other recordings. But as you see, the difficulty here, my Lord, is nothing is dealt with, or should I say, well, certainly in the answering affidavit, there's nothing of substance, certainly not factual. And secondly, there are no subsequent affidavits to deal with these events, and we've made our case.
Yes.
My Lord, so come back to Rex versus really there, the usefulness of, we've made up the case that it exists and that it's useful to us and that it's relevant. The submission made that we haven't dealt with relevance is without any substance whatsoever, my Lord. My Lord, just a couple of responses. King's case does not call the C-clip working product. And if there was the product of work in the C-clip, C-section, why is it not in the answering affidavit? Well, it's not. I just come to, again, reference back to Rex versus Penny. You can't deal with the relevance of anything unless you have some insight into it and its existence. Had they made out a case under oath in the answering affidavit, we could have arguments around relevance. They haven't raised relevance, certainly not on a factual basis. The learned friend made the submission that he made the concession that the investigation started before the opening of the Littleton docket. Well, we've said that's evident from what we've received. Again, you don't find anything to that effect in the answering affidavit, but we're entitled to all of it. Whether they have to open the docket at this time or that time, we don't need to get into that debate. Everything in relation to the investigation, falling under the sections, must be disclosed. Section C is going to tell us more about that. Wolf's case remains applicable, not for the reasons our learned friend submitted. We've told you that related, that was a tax matter. Mr. Kerpillet has spoken to that. King, you'll recall, in the heads of argument put up by the state, they start off by relying on King. King is no support for any of their contentions, my Lord. Your Lordship, Mr. Lowe correctly refers you to the first 4 paragraphs. We rely on them too. Lastly, my Lord, it was interesting, and I don't mean in any respect to be insulting to Mr. Lowe, because Mr. Lowe is, as I said, a recent incumbent. But if you remember their heads of argument, this is the last issue I want to deal with. If I must estimate the percentage-wise, I think 95 or 98% of their heads of argument, let's say 95, let's say 90, dealt with condonation. We'll recall that our application came one day late. The entire heads of argument...
It's no longer an issue yet.
It's not an issue, but
Yes.
the point is this. That whole set of heads of argument is they fight us on the basis of condonation. And then the concluding paragraph is to the effect that we're nitpicking. Now, I'm glad Mr. Lowe would never have come and argued on the basis of those heads of argument. But everything that he says in the submissions he makes in and around a prosecutor, that's good, and we trust. Well, we accept that might be how Mr. Lowe conducts himself. Yes. But Mr. Lowe is not the person who has been running this matter from the investigation stage in the directorate. Had he been, I don't believe we would have been here based on his submissions to your lordship. Who has made the decisions, how they've made the decisions, why they've made the decisions, why they've gone and done the things that they've done, why we're in a position to attack them the way we do in the founding affidavit, speaks to the conduct of another prosecutor and other people involved in the investigation. Lord, there's just a plethora of evidence in our affidavits. You've heard our submissions. This is a matter, my Lord, that cries out for disclosure. And if we just look at the period that we've come before your lordship, and we see the backwards and forwards, committing and then reneging. Lord, there's something to be hidden here, just when one looks at it at the highest level of assessment. And if there was anything more, my Lord, with the greatest of respect, we believe your lordship would have in any event called for it, for the very least, the judicial plea. My Lord, we leave the matter in your hands. I don't believe there's anything in regard to condemnation, as you have indicated to me, my Lord. Anything else that you would be inclined to direct your mind to, that we would ask you set out in the practice note. And our notice of motion, my Lord, is clear on its terms. I did find my copy of the notice of motion. The last prayer is a catch-all. It was 1.6, my Lord. Might I just take a closing instruction?
Yes.
My Lord, those are our submissions, as your lordship pleases.
Today is the last day of term.
Beg your lordship's pardon?
Today is the last day of term.
Indeed it is, my Lord.
Yes, you are going on research.
Yes.
But I can deliver this judgment if you are all available on Friday, next week Friday.
Next week Friday. Yes, we'll make ourselves available.
Are you available, Mr. Lowe?
Lord, I'm not sure, but if I'm not, is it
Ms. Ramsey can note judgment. Yes.
Suitable.
Are you available, Mr. Wos?
Yes, I am available next week.
Yes. What is the date on Friday?
I think it's the 5th.
5.
4th, my Lord.
Yes, I want to take this opportunity and thank all council for your contributions and inputs. You have greatly assisted me in coming to a proper determination. Even though your papers are always late, Mr. Wos. Yes.
My journey's back.
But I appreciate the effort.
Yes, as the Lord.
Lady, I should stand up. I hope you are in a position who can follow what was happening.
Ndiyathemba ke ukuba ubufuneko akukwazi nobono bakukancinane ulandele ukuba bekusenzela njani.
It is unfortunate that submissions by counsel, respective counsel, are not interpreted to accused in this court.
Ngelishwa ke asiye sibe nalo ithuba lokuba sikwazi ukutolika imiqondisano eyenzekayo phakathi kwegqwetha lakho nabo bezithuthisa ngomnqayelo.
But in summary, the argument was about the disclosure of the docket.
Kodwa xa sinokuthi sibe seyishwa ngathela le miqondisano imikhona amacala omabini ibiphathelene necandelo elithile apha kwidokethi eli yakhe liphawulokwazi.
The state has considered to disclose the A and B section of the docket.
Bezithuthisiso ke bavumile into yokokuba icandelo A no B bakwazile ukubanika amavumelo.
And what is outstanding is the C section of the docket and the bigger docket.
Eyona ndawo ke ngoku isaqalelayo okanye abazekayo inikwa aba bakumeleyo leli candelo lingusikwa kunye nelinye idokethi.
I'm not going to give judgment on the application which is made by your counsel, but I'm going to reserve judgment and deliver judgment on the 4th of April 2025.
Andizokusinikeza ke kuba kaloku nje isigqibo endizawuthi ndibe ndisinika kwisicelo besenzeke igqirha lakho ndawuyenza yonke loo nto kodwa ngomhla wesine kwinyanga kaJulayi.
So you want to be here at 10 o'clock on the 4th of April 2025. You're on bail, your bail is extended on same conditions.
Inkundla iyakulumkisa nomuyele kule nkundla ngomhla wesine kwinyanga kaApril kulo nyaka sikuwo ngentsimbi yeshumi kusasa imiqathango ke isami ngobume bayo kwibhili yakho.
Yes. Court agents.